For this video, we are going to discuss Articles 141 and Articles 142, both of the Revised Penal Code. I am referring to the crimes of conspiracy to commit sedition and inciting to sedition. Let's start with Article 141, conspiracy to commit sedition. Persons conspiring to commit the crime of sedition shall be punished by prison correctional in its medium period and a fine not exceeding 400,000 pesos. Again, I suggest that for the proper understanding of this very short provision or very short article in Article 141, you need to review your knowledge on conspiracy. I am referring to Article 8 of the Revised Penal Code. And also your knowledge of or on the crime of sedition. I am referring to Article 139, which I have also previously discussed in my video. Because what we are going to talk about here is the conspiracy to commit the crime of sedition. So much so that in order for this crime to exist, the persons conspiring or the persons who come to an agreement concerning the commission of a felony and decide to commit it, there must be what? An agreement and a decision to, number one, rise publicly and tumultuously. Why? Because this is one of the elements of sedition, that the offenders rise publicly and tumultuously. And second, there must also be an agreement and a decision at the same time to attain any of the objects of sedition as enumerated in Article 139. Because if there is only an agreement and a decision to attain any of the objects of sedition without an agreement and a decision to rise publicly and tumultuously, then the crime is not committed, and vice versa. Because if there is only an agreement and a decision to rise publicly and tumultuously without a corresponding agreement and a decision to attain any of the objects of sedition, then there is also no crime under this article. Also take note that unlike in rebellion and coup d'etat, there is no crime of proposal to commit sedition. Again, unlike in rebellion or insurrection and coup d'etat, there is no crime of proposal to commit sedition. There is only a crime of conspiracy to commit sedition. You might ask, bakit ganyan, Fiscal? I don't know, no? The legislators may have forgotten or they may have opted not to punish the mere proposal to commit the crime of sedition. Let's now go to Article 142, inciting to sedition. The penalty of prison correctional in its maximum period and a fine not exceeding 400,000 pesos shall be imposed upon any person who, without taking any direct part in the crime of sedition, should incite others to the accomplishment of any of the acts which constitute sedition, by means of speeches, proclamations, writings, emblems, cartoons, banners, or other representations tending to the same end, or upon any person or persons who shall utter seditious words or speeches, write, publish, or circulate scurrilous libels against the government, or any of the duly constituted authorities thereof, or which tend to disturb or obstruct any lawful officer in executing the functions of his office, or which tend to instigate others to cabal and meet together for unlawful purposes, or which suggest or incite rebellious conspiracies or riots, or which lead or tend to stir up the people against the lawful authorities, or to disturb the peace of the community, the safety and order of the government, or who shall knowingly conceal such evil practices. What are therefore the different acts of inciting to sedition? Number 1. When the offender incites others to the accomplishment of any of the acts which constitute sedition by means of speeches, proclamations, writings, emblems, cartoons, banners, or other representations tending to the same end. Here, take note that the offender, I am referring to the one inciting the others to the accomplishment of any of the acts which constitute sedition, must not take part in the crime of sedition itself. Otherwise, he will be liable for sedition. He will be no longer be liable for inciting to sedition, meaning the inciting will be deemed absorbed in the sedition itself because of his taking a direct part in the crime of sedition. If he only incites others but does not take part, then he will only be liable for the crime of inciting to sedition. Second act of the crime of inciting to sedition, when the offender utters seditious words or speeches which tend to disturb the public peace. And another is when the offender writes, publishes, or circulates scurrilous libels against the government or any of the duly constituted authorities which tend to disturb or obstruct any lawful officer in executing the functions of his office, or which tend to instigate others to cabal and meet together for unlawful purposes, or which suggest or incite rebellious conspiracies or riots, or which lead or tend to stir up the people against the lawful authorities, or to disturb the peace of the community, the safety and order of the government, or who shall knowingly conceal such evil practices. Take note that in Numbers 2 and 3, I am referring to the second and third acts that constitute the crime of inciting to sedition. It is not necessary that the purpose of the offender is to incite the others to the accomplishment of any of the objects of sedition, because that is so provided already in the first punishable act. What I'm trying to say is that in the second and third punishable acts of the crime of inciting to sedition, it is enough that the words uttered or the scurrilous libels against the government would tend to disturb any lawful officer in executing the functions of his office. Again, it is not necessary that the lawful officer is actually disturbed in the execution of the functions of his office. It is enough that the words uttered or the scurrilous libels made against the government by the offender would tend or would give the possibility that the lawful officer would be disturbed in the performance of the functions of his office. Allow me to share to you some examples mentioned by Reyes in his book in Criminal Law. The examples I am referring to are his examples on the different acts of the crime of inciting to sedition. So let's start with the first act or punishable act of the crime of inciting to sedition, which is uttering seditious words. The author cited the case of People versus Perez. This is found in 45 Philippine Reports 599. Here the accused uttered the following words: "The Filipinos, like myself, must use bolos for cutting off Wood's head, for having recommended a bad thing for the Filipinos, for he has killed our independence." The Wood he was referring to here was Governor General Wood, who was the Governor General at the time when the Philippines was still under the sovereignty of the United States. Can you imagine his statement? He suggested that the Governor General's head should be cut off, and He was charged and convicted in the trial court. He appealed this case in the Supreme Court, but the Supreme Court sustained his judgment of conviction and maintained that the accused indeed uttered seditious words. He incited others, to commit the crime of sedition because his suggestion was to kill the head of the Philippine government at that time, Governor General Wood. And at that time, those words were deemed seditious. Although at present, yes, I still would like to believe that inciting others to kill the president of the Philippines would be seditious. And you might be held liable for the crime of inciting to sedition if you post those words on Facebook or in any other social media platform. Also, the author cited the case of People versus Nabong in reference to the second punishable act in the crime of inciting to sedition, which is uttering seditious speech or seditious speeches. Here, the accused made the following speech. The accused here made reference to the Philippine Constabulary, the predecessor of the Philippine National Police. And this is what he said to the members of the Philippine Constabulary. They committed a real abuse in seizing of the flag. The members of the Constabulary are bad because they shoot even innocent women, as it happened in Tayug. In view of this, we ought to be united to suppress that abuse, overthrow the present government, and establish our own government, the government of the poor. Use your whip so that there may be marks on their sides. The Supreme Court made the following pronouncement, and I will quote exactly the words used by the author in his citation of the decision of the Supreme Court. The Supreme Court said, the words used by the accused manifestly tended to induce the people to resist and use violence against the agents of the constabulary and to instigate the poor to cabal and meet together for unlawful purposes. They also suggested and incited rebellious conspiracies, thereby tending to stir up the people against the lawful authorities and to disturb the peace of the community and the order of the government. And here is the important part. It is not necessary in order to be seditious that the words used should in fact result in a rising of the people against the constituted authorities. The law is not aimed merely at actual disturbance, as its purpose is also to punish utterances which may endanger public order or public safety. Also, the author made mention of the case of Espuelas versus People in his reference to the third punishable act in the crime of inciting to sedition. And the third punishable act in the crime of inciting to sedition is writing, publishing, or circulating scurrilous libels against the government or any of the duly constituted authorities thereof. The word scurrilous here means low, vulgar, mean, or foul. And this is what happened to that case. These are the facts of the case. The accused had his picture taken, making it to appear as if he were hanging lifeless at the end of a piece of rope suspended from a tree. He sent copies of the photograph or of the picture to newspapers of general circulation and appended a suicide note, allegedly written by a fictitious suicide, Alberto Reviniera, and addressed to the latter's supposed wife. The note contained words that he committed suicide because he was not pleased with the administration of President Rojas, and that our government is infested with many Hitlers and Mussolinis, for which reason he cannot hold high brows to the world with his dirty government. He instructed his children to burn pictures of Rojas if and when they come across them. Those were the words written in his supposed letter to the wife of a supposed person who allegedly committed suicide. Accordingly, he was charged and then he was convicted by the trial court. He appealed this case to the Supreme Court, and the Supreme Court made the following pronouncement. It said, the letter is a scurrilous libel against the government. Writings which tend to overthrow or undermine the security of the government or to weaken the confidence of the people in the government are against the public peace and are criminal not only because they tend to incite to a breach of the peace, but because they are conducive to the destruction of the government itself. So take note of these cases cited by the author, although they are already old cases, but they are still controlling as of the present.